We'd like to have a very exciting sharing with you on this particular segment of our YouTube upload because what we will have here is a discussion of the new features of the revised corporation law of 2019 as we compare with the Batas Pambansa number 68 of 1980 where the corporation law was also issued. We have decided to zero in on this particular session on those provisions of the revised corporation law that represent changes. And we would handle the details of the corporation law in subsequent uploads where we will discuss the corporation law together with the revisions in 2019 on a complete flow basis. But for this particular upload, we shall only be zeroing in on those provisions that are new under the revised corporation law of 2019. Allow me to dedicate this little sharing with Dr. Virgilio Domingo de los Santos, the late chairman of the board and president of the University of Manila, because I spent a number of opportunities and occasions uh, solving legal problems with him involving corporation. And so I would like to dedicate this particular special version on the new provisions or the revised provisions of the corporation law as approved in 2019. Without much ado, let us start the ball rolling by allowing me to introduce myself. I am Dean Joe-Santos Balagtas Bisquera. I hold a Bachelor of Business Administration degree, major in accounting, and a certified public accountant, University of the East, summa cum laude. I have my Master of Business Administration degree, MBA, University of the Philippines, Diliman, where I graduated magna cum laude and valedictorian. I finished my Bachelor of Laws degree, University of the East, cum laude and class valedictorian. After I finished my Bachelor of Business Administration degree, and after I took up the CPA board exam, I immediately joined the corporate world, rising gradually from financial analyst with then ESO, which became Petron, to finally become Executive Vice President and Chief Finance Officer of Fuji Xerox. So in addition to Fuji Xerox, I was also with Motorola Philippines. I had a stint in the pharmaceutical industry, GlaxoSmithKline. I did mention my first career was in ESO Petron. And just hold on for a minute. Let me just arrange this. And I also had stints with GlaxoSmithKline. I already mentioned that. I had a stint with Meralco's construction division, EcoAsia, that handled the electromechanical component of the Bataan nuclear power plant. I also work with Delgado Brothers Incorporated, with FMC's Furodan, an American company in the agricultural chemical field, and I had my stint with the World Bank doing two major projects with them in the fisheries sector and with local water utilities administration on the water system, where I did the 10-year financial projections of LUA. After I finished my bar exams, I immediately tried to appear in court, even if I was full time with the corporate world, taking leaves. And I was a practicing lawyer, appearing in the regional and metropolitan trial courts in Metro Manila and the nearby provinces. That allowed me to be nominated twice, Associate Justice Supreme Court of the Philippines, and also professorial lecturer in criminal law and mercantile law, Philippine Judicial Academy. I already mentioned that I am the Dean of the College of Law, University of Manila, the Vice President for Legal Affairs, and a member of the Board of Trustees. Sometime in 2009 to 2011, I was also the Dean, Colleges of Law at Las Piñas and Binyan of the University of Perpetual Health. I have been an MBA professor in financial management at the De La Salle University for 35 years, 10 years at the University of the Philippines in Diliman, and a few years at the University of the East. I've been bar reviewer and law professor at the University of the East, University of Santo Tomas, De La Salle University, University of the Philippines, San Sebastian College, and Far Eastern University. To start the ball rolling on the corporation law updates, zeroing in on the revised corporation law of 2019, allow us to start with comparing the substantive changes between the revised corporation law under Republic Act 11232 of 20 February 2019 versus the Corporation Code under BP 68 of May 1, 1998. Under the subject matter of incorporation and organization, it would be worthwhile for us to again remind ourselves on what a corporation means. Under Section 2 of the Revised Corporation Code, it says, a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence. Insofar as the corporate term is concerned, this is one of the significant new features of the revised corporation code. In the revision, it says a corporation shall have perpetual existence unless its articles of incorporation provides otherwise. In the Corporation Code of 1980, corporations have 50-year life subject to a renewal for another 50 years. In the 2019 revision, the legislature has decided to extend perpetual existence to corporations in the Philippines. Now, existing corporations at the time the revised corporation code was enacted, with certificates issued before the revised corporation code of 2019 was issued, shall have perpetual existence likewise, unless the corporation, upon a vote of its stockholders representing a majority of its articles of incorporation, retains its fixed term, provided that any change in the corporate life shall consider the right of dissenting stockholders in accordance with the provisions of this code. Just looking forward, we will recognize that when the life of the corporation is either extended, just like in this case, from a fixed term to a perpetual term or perpetual existence, or when the corporation decides to amend its articles of incorporation to shorten the life of the corporation, this is one occasion where dissenting shareholders can exercise the right to say goodbye by way of their appraisal right. Continuing with the subject matter of corporate term, a corporate term for a specific period may be extended or shortened by amending the articles of incorporation, which is what we were saying a while ago, provided that no extension may be made earlier than 3 years prior to the original or subsequent expiry date or dates unless there are justifiable reason or reasons for an earlier extension as may be determined by the Commission, SEC. Provided further that such extension of the corporate term shall take effect only on the day following the original or subsequent expiry date. A corporation whose term has expired may apply for revival of its corporate existence, together with all the rights and privileges under its certificate of incorporation, and subject to all of its duties, debts, and liabilities existing prior to its revival. Upon approval by the Commission, the corporation shall be deemed revived and a certificate of revival of corporate existence shall be issued giving it perpetual existence unless its application for revival provides otherwise. No application for revival of certificate of incorporation of banks, banking and quasi-banking institutions, pre-need, insurance and trust companies, non-stock savings and loan associations, pawn shops, corporations engaged in money service business, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agencies. We all know that banks, banking, and quasi-banking institutions, and non-stock savings and loan associations, pawn shops, and also corporations engaged in money service business and other financial intermediaries have the Bangko Sentral ng Pilipinas as the appropriate governing agency. On the other hand, pre-need insurance companies and to a certain extent trust companies are under the responsibility of the Insurance Commission. Moving now to incorporators. This is a new provision or a revised provision in the 2019 Corporation Code. And it reads, incorporator would be any person, partnership, association, or corporation, singly or jointly with others, but not more than 15 in number, may organize a corporation for any lawful purpose or purposes. In the 1980 Corporation Code, it reads any number of natural persons. Take note, in the 1980 Corporation Code version, only natural persons can be incorporators. In the 2019 Revised Corporation Code, juridical personalities are now capable of becoming incorporators, to include partnerships, associations, and equally corporations. And the limit, not less than five, which existed in the 1980 Corporation Code, has been obviously deleted in the 2019 Revised Corporation Code. But both the 1980 and 2019 Corporation Code versions kept the maximum of 15 incorporators as the ceiling. Likewise, you will notice that it is very clear that in the 1980 Corporation Code, the majority of the incorporators should be residents of the Philippines. And yet, in the 2019 Corporation Code, there is no requirement that any of the incorporators are residents of the Philippines, which means those who are abroad, whether Filipinos abroad or even foreigners, can become incorporators as natural persons or perhaps even members of partnerships, associations, or corporations. However, there is an exception to the issue of partnerships or even persons involved in the professions. Natural persons, it reads, who are licensed to practice a profession, and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. You will understand this because in the practice of the profession, it is the individual professional who becomes personally and professionally liable. And so if you allow the creation of a corporation under the concept that the corporation is separate and distinct from its stockholders, the professional therefore would have some difficulty being bound by any violation of his professional duties. And so therefore here, persons who are in the practice of the profession, either as persons or in partnership, will not be allowed to organize a corporation. Incorporators or natural persons must be of legal age. Continuing with the discussion on corporations, each incorporator of a stock corporation must own or be a subscriber to at least one share of capital stock. I think that is obvious. A corporation with a single stockholder is considered a one-person corporation as described in Title 13, Chapter 3 of this code. This particular YouTube upload has purposely did not include the discussion or one-person corporation. We will have a separate upload to discuss fully this new provision of the revised corporation code that provided a one-man corporation. By way of some comments, partnerships, associations, or corporations, we already said this, are artificial persons but can now be allowed to organize a corporation. And incorporators can now be from 1 to 2 persons and even less than 5 but not more than 15. If you will remember, under the 1980 Corporation Code, they cannot be less than 5. Under the 2019 Revised Corporation Code, it can be one person, which is the one-man corporation being mentioned here, or they can be 2 but less than 5. And that would still qualify as a legitimate corporation organized under SEC. And finally, incorporators need not be residents of the Philippines, as obviously when we compare the 2019 definition of incorporators versus the one in 1980 Corporation Code. And so There is no requirement so far under Section 10 of Title 2 of the Revised Corporation Code of 2019. Let us now move on to another major change in the Revised Corporation Code of 2019. And on the minimum capital stock, it reads, stock corporations shall not be required to have minimum capital stock except as otherwise specially provided by special law. Just for purposes of comparison, this very famous 25-25% rule has been set aside in the Revised Corporation Code of 2019. Under the 1980 Corporation Code, it reads, and this is the one in yellow, it says at least 25% of the authorized capital stock, as stated in the Articles of Incorporation, must be subscribed at the time of incorporation, and at least 25% of the total subscription must be paid upon subscription. The balance to be payable on the date or dates fixed in the contract of subscription without need of call, or in the absence of a fixed date or dates upon call for payment by the Board of Directors, provided, however, that in no case shall the paid-up capital be less than 5,000 pesos. That particular requirement is the minimum capital stock that was mandated under the 1980 Corporation Code. And we will notice under the 2019 Revised Corporation Code, such requirement does not exist. The Revised Corporation Code of 2019 no longer requires any minimum capital stock, nor the previous 25% rule on subscriptions and full payments. Let's move on now to corporate name. The 2019 Revised Corporation Code provides that no corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, rules, and regulations. So again, in terms of the corporate name should be distinguishable. So it says the corporate name, no corporate name shall be allowed if it is not distinguishable. So in the reverse, we're saying that SEC will only approve a corporate name if it is distinguishable from another corporate name that is reserved or registered in favor of another corporation, or if such name is already protected by law, rules, and regulations. Continuing with the corporate name, it is worthwhile to understand when is a name not distinguishable. In effect, it is the same as another corporate name, even if it contains one or more of the following. Letter A. If that name contains the word corporation, company, incorporated, limited liability, or an abbreviation, one of such words, then the addition of that word to a corporate name that already exists will not make the second corporate name distinguishable. So for example, if you have a corporate name Agua del Mar, and it is already a registered corporation, and then another businessman proposing to organize his company added now the word Agua del Mar Incorporated or Agua del Mar Limited. The fact that he is adding the word incorporated or limited to the name Agua del Mar that is already registered will not make his Agua del Mar Incorporated a distinguishable brand. The second one is if you added punctuations, articles, conjunctions, contractions, prepositions, abbreviations, different tenses, spacing, or number of the same word or phrase. Then, adding that to an existing name will not likewise make the second imitation corporate name to be distinguishable. For example, in our example, Agua del Mar. And what was added were three dots. Agua del Mar, dot, dot, dot. The originally registered corporate name did not have the dot, dot, dot. That particular series of period punctuations will not make Agua del Mar, the second one, valid for registration purposes. Another similar strategy would be Agua del Mar is the registered corporate name, and the second one proposing to register would put an article L, EL. So it will read now El Agua del Mar. The L there is simply an article or a preposition added to already an existing name. And so the Agua del Mar, originally registered, will continue to be protected by prior registration, and the adding of the L, EL, in front of it to read El Agua del Mar will not allow the SEC to register the second name as a valid or distinguishable corporate name. The SEC, it says here, the Commission, upon determination that the corporate name is number one, not distinguishable from a name already reserved or registered, or for example, number two, already protected by law. Or number three, contrary to law, rules, and regulations, may summarily order the corporation to immediately cease and desist from using such name and require the corporation to register a new one. The Commission shall also cause the removal of all visible signages, marks, advertisements, labels, prints, and other effects bearing such corporate name. Upon the approval of the new corporate name, the Commission shall issue a certificate of incorporation under the amended name. If you remember, there was this particular restaurant that before the enactment of this 2019 revised corporation law, and I don't even know, probably even before the 1980 corporation law, that particular restaurant somewhere in Quezon City already registered its name. And too bad, the name that it is carrying happens to be the international name of a leading international hotel. And considering the hotel is not only catering to occupants of the rooms, but they have their own set of restaurants. And that Quezon City Hotel is a restaurant carrying an identical name. If I remember, it must be Shangri-La. Then it became a very heated case before the Supreme Court. Under the present 2019 Corporation Code, that can no longer happen because if the original Shangri-La restaurant was ahead, then it will be too unfortunate that Shangri-La Hotel may be barred from using that international name Shangri-La Hotel. There is another additional portion there which says, if the corporation fails to comply with the Commission's order, Uh, I repeat, if the corporation fails to comply with the Commission's order, meaning to desist from using the corporate name that is uh, not distinguishable or not distinguishable, the Commission may hold the corporation and its responsible directors or officers in contempt and or hold them administratively, civilly, and or criminally liable under this code and other applicable laws and or revoke the registration of the corporation. So continuing now, let us move on to another topic where a particular group has already registered itself as a corporation and received the articles of incorporation, its birth certificate as a juridical person. Unfortunately, the organization, despite the issuance of the charter in its favor, happened not to operate. So if a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, its certificate of incorporation is revoked at the end of the 5-year period. So take note, it is 5 years now that is being used for non-use of the corporate charter and in operation. However, if a corporation has commenced its business, so it registered, for example, in 2019, but subsequently becomes inoperative, so it stopped on 2020 because of the COVID pandemic. So from 2020, it will now be inoperative for a period of at least 5 years, consecutive years. So 20, 21, 22, 23, 24 would be 5 consecutive years. Then the SEC may, after due notice and hearing, place the corporation under delinquent status. Take note, it is not the certificate of registration is not revoked when the corporation has already started its business but subsequently stops operations and did not operate for the next 5 years. It will not be, the certificate will not be revoked. The corporation will just be listed as a delinquent corporation. And a delinquent corporation shall have a period of 2 years, so 5 plus 2 is 7 years, to resume operations and comply with all requirements that the Commission shall prescribe. Upon the compliance by the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given by the SEC shall cause the revocation of the corporation's certificate of incorporation. So this is a very beautiful variation. So if a corporation duly register itself and receives a certificate of incorporation, so it's an existing valid artificial being before Philippine law, but it never started operation, it has 5 years, and on the 5th year, the certificate is automatically revoked. Now, the variation is if that particular corporation actually started operations, and after starting operations, and it doesn't indicate how long will the operation be, but that kind of going concern activity suddenly stopped, and then it did not resume for 5 years. If it did not start, that 5-year period of inaction will lead to a revocation of the certificate. But if they operated but stopped for 5 years, it does not automatically yield to revocation. They will get a status of what is called delinquent status. And they will be given due process of law. They will be advised that they are being considered delinquent because of their failure to resume operations. and they will now be given a grace period of 2 years so that if they operate within the 2-year period, then they will be considered as already operational and the delinquent status will now be lifted there. It says an order by the SEC lifting the delinquent status. However, if after 2 more years, which is 5 plus 2 is 7 years, still the organization did not resume operations, then that will now be calling for revocation of its certificate of incorporation. Continuing with the non-use of corporate charter and continues in operation, the SEC shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the suspension or revocation of the certificate of incorporation of companies under the special regulatory jurisdiction. Here, the very clear governing agencies here would be the Bangko Sentral ng Pilipinas for banks, quasi-banks, and other financial institutions, and then the Insurance Commission insofar as insurance, pre-need plans, and similar operations are concerned. Moving now to another subject matter, here we go to a corporation vested with public interest. The board of these corporations vested with public interest shall have independent directors, constituting at least 20% of such board. And so if you, for example, have a corporation with vested interest, and we will see what this vested interest is all about, and it has 10 members of the board, then 20% of 10 members, 10% of 10 is 1, so you double that, that's 20%, you have 2. So out of 10 corporate directors, 2 are supposed to be independent directors for corporations with public interest. Now, here is now a listing of the corporations with public interest. The first one, the first grouping, corporations covered by the Securities Regulation Act. This is Section 17.2, Republic Act 8799, whose securities are registered with the SEC. Second, corporations listed with an exchange, the Makati or the Manila or the Philippine Stock Exchange. Or third, corporations with assets of at least 50 million pesos and having 200 or more holders of shares, each holding at least 100 shares of a class of its equity shares. So in the first grouping of corporations with public interest, there are 3. Number 1, those corporations whose securities are registered with the Commission under the Securities Regulation Act, corporations that are listed in the stock exchange, and corporations with assets of 50 million and with 200 or more holders of shares, each shareholder holding at least 100 shares. The second group of corporations with vested interests would be the banks and quasi-banks, NSSLAS, pawn shops, corporations engaged in money service business, pre-need, trust and insurance companies, and other financial intermediaries. They are considered the second group of corporations with public interest. The third one, other corporations engaged in businesses vested with public interest similar to the above, as may be determined by the SEC, after taking into account relevant factors which are germane to the objective and purpose of requiring the election of an independent director, such as the extent of minority ownership, type of financial products or securities issued or offered to investors, public interest involved in the nature of business operations, and other analogous factors. Continuing with corporation vested with public interest, An independent director is a person who, apart from shareholdings and fees received from any business or other relationship which could reasonably be received to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. Independent directors must be elected by the shareholders. By the shareholders present or entitled to vote in absentia during the election of directors. Independent directors shall be subject to rules and regulations governing their qualifications, disqualifications, voting requirements, duration of term and term limit, maximum number of board membership, and other requirements that the Commission will prescribe to strengthen their independence and align with international best practices. I would just like to call your attention to the mention here of voting in absentia. And while we may not be fully emphasizing this in this presentation, the voting in absentia or the voting via teleconferencing is one of the new features of the 2019 revised corporation code. Just take note of that particular feature. Moving further, on the board of directors, we now go to the election of directors. A favorite among Filipinos, no? Election. So under sections 23 and 7, it mentions here, except when the exclusive right is reserved for holders of founder shares under section 7, each stockholder or member shall have the right to nominate any director or trustee who possesses all the qualifications and none of the disqualifications set forth in this code. At all elections of directors or trustees, there must be present, either in person or through a representative authorized to act by written proxy, the owners of majority of the outstanding capital stock, or if there be no capital stock, a majority of the members entitled to vote. When so authorized in the bylaws or by majority of the board of directors, the stockholders or members may also vote through remote communication. This is what I was mentioning a while ago, that you can undertake video conferencing, and remote communication is one way to participate and cast your vote, provided authorized by the bylaws or by the majority of the board of directors. Or they can also vote in absentia, provided that the right to vote through such modes may be exercised in corporations vested with public interest, notwithstanding the absence of a provision in the bylaws of such corporation. So, the right to do remote communication or in absentia, attendance and participation in voting would have to be authorized in the bylaws or majority of the board of directors. That's one rule. However, for corporations with vested with public interest, even if there is no provision in the bylaws, then they will be allowed to participate through remote communication and in absentia. That's why it's very important to take note of the three types of corporations vested with public interest. Remember that, no? The first grouping would be, of course, those registered under the Securities Regulation Act, right? And the second one would be the banks and what they call this quasi banking, financial intermediaries. And the third one would be those that are exercising similar types of businesses. A stockholder or member who participates through remote communication or in absentia shall be deemed present for purposes of a quorum. So when you raise the question of quorum, Those who are, for example, in Zoom Meet or in Microsoft Team or in Google Meet would be counted insofar as determining whether there is a quorum or not. Next, the election must be by ballot if requested by any voting stockholder or member. This particular provision has been inserted there because of those who are familiar with parliamentary procedure. Some people think that the only way to vote is the raising of hands, the so-called viva voce principle, rather than, of course, casting your ballot or individual roll call vote. No. The easiest way for a presiding officer to accelerate the process is to pick up a proposal, a resolution, proposed resolution, and say as many, without saying as many is in favor, the presiding officer will say that there is a resolution now here for discussion. Are there any objections? And the moment the smart chairman says, are there any objections? And those who are opposed to it are not conscious about that kind of mode of votation. If the chairman does not hear any objection, then the chairman bangs his gavel and says that particular resolution is unanimously approved. And in sharing corporation law with so many of my friends, I always give them that particular thing which is not studied in law school, except now that we are talking about it. That's learned in parliamentary procedure. So when you're a presiding officer and you want to accelerate and there is a proposal, especially if you can anticipate there are some noisy guys there in the audience, but they're not so familiar with parliamentary procedure, you now present you now ask the movant or the presenter to present his resolution or his motion. And in order to accelerate, you can now say there is a motion or there is a motion on the table. Are there any objections? That's your first option. Are there any objections? You count from 1001, 1002, 1003, 1004, 1005, and then you bang, the resolution or the motion is carried unanimously. Okay. The second one, which is a question again of parliamentary strategy in the floor, is if there are a number of debates, but you can sense that the majority on the floor are really getting bored or getting irritated with the filibuster, then you can now say the chair now puts this into a vote. As many as are in favor of, for example, the motion or the resolution as proposed, say A. And of course, if you have a bulk of people attending there who are not filibusters but they're getting irritated, they will raise their voice and say A. And if you say as many as are against, say nay. And you may have only one or two who are the oppositionists who will say nay. Then you make a declaration that the ayes have it, the resolution or the motion is approved. Okay, that's the second parliamentary strategy. Now, if you are in the audience and you are a minority, but you can sense that people are being stifled, then you now say, Mr. President or Mr. Presiding Officer, I move for a division of the House. And by the division of the House, he is referring to the raising of hands. And, if the chairman is very smart, he says, the motion is overruled because we have already voted upon it by way of the ayes and nays. And, of course, the one who's objecting would say, I move for a reconsideration of the chair's ruling. I would like to move for a raising of hands so that the exact votes will be counted. Because the ayes have it, the nays have it, there is no counting of votes. And so if you are the one raising an opposition, you raise I move for a raising of funds so that the exact votes will be counted. Natalo ka pa din, So you now go for a what? You go for a nominal vote, which is exactly done when it's a crucial battle, a parliamentary battle before either the Senate or the House of Representatives. Honestly, these parliamentary procedures are not taken up officially in the College of Law. And as the Dean, I am planning to offer an elective on parliamentary procedure because if you do not know parliamentary rules, you cannot be a chairman of the board or you cannot be a presiding officer. And it is very embarrassing if you have that kind of function and you do not know what to do. Continuing with the election of directors. In stock corporations, stockholders entitled to vote shall have the right to vote the number of shares of stock standing in their own names in the stock books of the corporation at the time fixed in the bylaws or where the bylaws are silent at the time of the election. The said stockholder may A. Vote such number of shares for as many persons as there are directors to be elected, or B. Cumulate said shares and give one candidate as many votes as the number of directors to be elected multiplied by the number of shares owned. Or C. Distribute them on the same principle among as many candidates as may be seen fit, provided that the total number of votes cast shall not exceed the number of shares owned by the stockholders as shown in the books of the corporation, multiplied by the whole number of directors to be elected, provided, however, that no delinquent stock shall be voted, unless otherwise provided in the Articles of Incorporation or in the bylaws. Members of non-stock corporations may cast as many votes as there are trustees to be elected by may not cast more than one vote for one candidate. Nominees for directors or trustees receiving the highest number of votes shall be declared elective. In all candidates, my dear friends, allow me to ask your indulgence that in the second round of discussion of corporation law, I will discuss this in detail. I just want to set aside the detailed explanation of this manner of voting because we would like to give focus to the new provisions or the amended provisions of the 2019 revised corporation code. So we will come back to that in subsequent presentations. Continuing now in the area of the board of directors, still on the election of directors. If no election is held, and this can be done, no, to be able, if I may use the Tagalog word, lutong Macau, some officers would like to hold on to power indefinitely. So they will not hold an election and they will continue to carry on as holdover officers. So if no election is held, or the owners of majority of the outstanding capital stock, or majority of the members entitled to vote are not present in person, by proxy, or through remote communication, or not voting in absentia at the meeting, such meeting may be adjourned and the corporation shall proceed in accordance with Section 25 of this code. We will get into Section 25 soon. Continuing, the directors or trustees elected shall perform their duties as prescribed by law, rules of good corporate governance, and bylaws of the corporation. Now, another requirement on the election of the board of directors is the report to the SEC of the election of the directors. And here is now Section 25. It says, within 30 days after the election of the directors, trustees, and officers of the corporation, the secretary or any other officer of the corporation shall submit to the SEC the names, nationalities, shareholdings, and residence addresses of the directors, trustees, and officers elected. Continuing, the non-holding of elections and the reasons therefore shall be reported to the Commission within 30 days from the date of the scheduled election. The report shall specify a new date for the election, which shall not be later than 60 days from the scheduled date. This is the provision that is being referred to here if there was no election that was conducted. The non-holding of the election and the reasons will have to be reported to the SEC within 30 days from the date of that scheduled election. And the report shall specify a new date. So the date that was set up here was not followed because there was no election. And so the report of the non-holding of the election will mandate the directors, incumbent directors, to report a new date for the election when there is a deadline. It should be 60 days from the scheduled date, meaning 60 days from the time the meeting was convened and the election was not pushed through. So you have 30 days to report that the election was not conducted, the reason for the non-conducting of the election, and you have now the need to report when will be the new date, which shall not be more than 60 days from the original scheduled date. Continuing with the report of election of directors, it says if no new date has been designated or if the rescheduled election is likewise not held, so the second election was also not held, the SEC may, upon application of a stockholder, member, director, or trustee, and after verification of the unjustifiable non-holding of the election, summarily order that an election be held. The SEC shall have the power to issue such orders as may be appropriate, including other directing the issuance of a notice stating the time and place of the election, designated presiding officer, and the record date or dates for the determination of stockholders and members entitled to vote. Continuing now on the report of election of directors. Notwithstanding any provision of the Articles of Incorporation or bylaws to the contrary, the shares of stock or membership represented at such meeting and entitled to vote shall constitute a quorum for purposes of conducting an election under this code, meaning these are the elections being conducted after one or two postponements. Should a director, trustee, or officer die, resign, or in any manner case to hold office, the secretary or the director, or trustee, or officer of the corporation shall within 7 days from knowledge thereof report in writing such fact to the commission. Now let's now go to the corporate officers. A new provision. Immediately after their election, the directors of a corporation must formally organize and elect, letter A president who must be a director. B, a treasurer who must be a resident of the Philippines, not necessarily a director. And letter D, such other officers as may be provided in the bylaws. I notice here that what was skipped was the secretary who may or may not be a director. If the corporation is vested with public interest, the board shall also elect compliance officer. The same person may hold 2 or more positions concurrently, except that no one shall act as president and secretary or as president and treasurer at the same time unless otherwise allowed in this code. Under this slide, what was missed was letter C, which refers to the secretary of the board. Continuing with the corporate officers. The officer shall manage the corporation and perform such duties as may be provided in the bylaws and or as resolved by the board of directors. Moving now to the removal of a director. Any director or trustee of a corporation may be removed from office by the vote of stockholders holding or representing at least two-thirds of the outstanding capital stock, or in a non-stock corporation by a vote of at least two-thirds of the members entitled to vote, provided that such removal shall take place either at a regular meeting of the corporation or at a special meeting called for the purpose, and in either case after previous notice to stockholders or members of the corporation of the intention to propose such removal at the meeting. That means the removal of director will be one of the items in the agenda, whether it is a regular meeting or a special meeting called for the purpose. A special meeting of the stockholders or members for the purpose of removing any director or trustee must be called by the secretary on order of the president or upon written demand of the stockholders representing or holding at least a majority of the outstanding capital stock or a majority of the members entitled to vote. If there is no secretary, or the secretary despite demand fails to refuse or refuses to call the special meeting or to give notice thereof, the stockholders or members of the corporation signing the demand may call the special meeting. They themselves will call the special meeting or give notice thereof. The stockholder or member of the corporation signing the demand may call for the meeting by directly addressing the stockholders or members. So the secretary can be bypassed and any stockholder can proceed to act in order to call a meeting for the ouster of a director, removal of a director. Notice of the time and place of such meeting, as well as of the intention to propose such removal, must be given by publication or by written notice prescribed in this code. Removal may be with or without cause. So there is no illegal dismissal for a director. You know, a director, this was already decided in the past by the Supreme Court. So removal may be with or without cause, provided that removal without cause may not be used to deprive minority shareholders or members of the right representation to which they may be entitled under Section 23 of this code. Take note, this is a very significant component, that there should always be the minority shareholder represented in the board. And so that therefore, if the minority shareholder attending the board is the one being removed without cause, then there can be a violation of the corporation code. And this can be brought up before the Securities and Exchange Commission. But if the removal is with cause, like for example, conviction of a crime and similar things, disloyalty and so on, then the removal may be done, but that particular position must be replaced by somebody who will continue to represent the minority shareholders in the board. Continuing with the removal of director, it reads, the commission shall motu proprio or upon verified complaint and after due notice and hearing, order the removal of a director or trustee elected despite the disqualification or whose disqualification arose or is discovered subsequent to an election. The removal of a disqualified director shall be without prejudice to other sanctions that the Commission may impose on the Board of Directors or Trustees who, without knowledge of the disqualification, fail to remove such director or trustee. Now, after we talk about removal, let us talk about vacancies of director. Any vacancy occurring in the Board of Directors or Trustees other than by removal or expiration of term may be filled by the vote of at least majority of the remaining directors or trustees if still constituting a quorum. Otherwise, said vacancies must be filled by the stockholders or members in a regular or special meeting called for the purpose. So, if there is a vacancy in the position of director, not arising from removal or expiration of term. Then the majority of the remaining directors, if they still have a quorum, can fill up the vacancy. But if the remaining directors who cannot anymore form a quorum, then the vacancy will have to be referred to the stockholders who will vote in a regular meeting to fill up that particular vacancy. When the vacancy is due to term expiration, the election shall be held no later than the day of such expiration at a meeting called for that purpose. When the vacancy arises as a result of removal by the stockholders or members, the election may be held on the same day of the meeting, authorizing the removal, and this fact must be so stated in the agenda and notice of said meeting. In all other cases, the election must be held no later than 45 days from the time the vacancy arose. A director or trustee elected to fill vacancy shall be referred to as a replacement director. I repeat, replacement director or trustee elected to fill a vacancy shall be referred to replacement director or trustee and shall serve only for the unexpired term of the predecessor in office. Continuing with vacancies of the director, it says, however, when the vacancy prevents the remaining directors from constituting a quorum, an emergency action is required to prevent grave, substantial, and irreparable loss or damage to the corporation. The vacancy may be temporarily filled from among the officers, not necessarily director, among the officers of the corporation by unanimous vote of the remaining directors or trustees. The action by the designated director or trustee shall be limited to the emergency action necessary, and the term shall cease within a reasonable time from the termination of the emergency or upon election of the replacement director or trustee, whichever comes earlier. The corporation must notify the Commission within 3 days from the creation of the emergency board, stating therein the reason for its creation. Let's now move to the subject matter of meetings, but before that, we will finish the vacancies on director. Any directorship or trusteeship to be filled by reason of an increase in the number of directors or trustees shall be filled only by an election at a regular or a special meeting of the stockholders or members duly called for the purpose, and in the same meeting authorizing the increase of directors or trustees if so stated in the notice of the meeting. So the procedure is there will be an announcement in the agenda that the number of directors are to be increased. And in that same meeting, the election of the additional directors can be undertaken, provided there was notice immediately prior to the meeting. In all elections to fill vacancies under this section, the procedure set forth in Section 23 and 25 of this code shall apply. Now, let us now move to Stockholders Meeting under Section 50. Stockholders or members' meetings, whether regular or special, shall be held in the principal office of the corporation, as set forth in the Articles of Incorporation, or if not practicable, like for example, if there is this COVID pandemic, in the city or municipality where the principal office is located, provided that any city or municipality in Metro Manila, Metro Cebu, Metro Davao, and other metropolitan areas shall purposes of this section be considered a city or municipality. Notice of meeting shall be sent to the means of communication provided in the bylaws, which notice shall state the time, place, and purpose of the meetings. Continuing with the stockholders' meetings, it says, Each notice of meeting shall further be accompanied by the following. Letter A, the agenda of the meeting. Letter B, the proxy which shall be submitted to the corporate secretary within a reasonable time prior to the meeting. Letter C, when the attendance, participation, and voting are allowed by remote communication or in absentia, the requirements and procedures to be followed when a stockholder or member elects either option. And letter D, when the meeting is for the election of directors or trustees, the requirements and procedure for nomination and election. Continuing now, still on stockholders meetings, all proceedings and any business transacted at the meeting with the stockholders or members, if within the power or authority of the corporation, shall be valid even if the meeting is improperly held or called. Meaning the notice must have been sent late, and all of this, provided that all the stockholders or members of the corporation are present or duly represented at the meeting, and not one of them expressly states at the beginning of the meeting that the purpose of their attendance is to object to the transaction of any business because the meeting is not lawfully called or convened. Now, let us now go to directors' meetings. Unless the articles of incorporation or the bylaws provides for a greater majority, a majority of the directors or trustees, as stated in the articles of incorporation, shall constitute a quorum to transact corporate business. And every decision reached by at least a majority of the directors or trustees constituting a quorum, except for the election of officers which shall require the vote of a majority of all the members of the board, shall be valid as a corporate act. This particular provision becomes very complicated when you have corporations with mass membership. Even in cooperatives where each cooperative member is expected to attend, it is very difficult to constitute a quorum. And I have handled some very tough situation here that I may not have the opportunity to discuss here. One, because of the time limitation. The second one is I may not be at liberty because of client-lawyer relationship to open up the subject matter. Regular meetings of the board of directors or trustees of every corporation shall be held monthly unless the bylaws provide otherwise. And special meetings of the board of directors or trustees may be held at any time upon the call of the president or as provided in the bylaws. Continuing with the directors meeting, meeting of directors or trustees of corporations may be held anywhere in or outside of the Philippines. Take note, can be held anywhere inside or outside of the Philippines unless the bylaws provide otherwise. Notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustee at least 2 days. It used to be 1 day. 2 days prior to the scheduled meeting unless a longer time is provided in the bylaws. A director or trustee may waive this requirement either expressly or impliedly. Moving now to another topic, merger and consolidation. Before we go into that, let's finish some more notes on the directors meeting. Directors or trustees who cannot physically attend or vote at board meetings can participate and vote through remote communication such as video conferencing, teleconferencing, or other alternative modes of communication that allow them reasonable opportunities to participate. Directors or trustees cannot attend or vote by proxy at board meetings. Take note, there is no proxy voting or proxy attendance by directors in board meetings. Only the proxies are only allowed in stockholders meetings. A director or trustee who has a potential interest in any related party transaction must recuse from voting on the approval of the related party transaction without prejudice to compliance with the requirements of Section 31 of this code. Now, let us now move to mergers and consolidations. The more important new provision under the Revised Corporation Code of 2019 is under Section 77, which reads, after the approval by the stockholders or members as required by the preceding section, meaning Section 76, articles of merger or articles of consolidation shall be executed by each of the constituent corporations to be signed by the President or Vice President and certified by the Secretary or Assistant Secretary of each corporation setting forth. The plan of the merger or consolidation. These are the contents of the articles of merger. As to stock corporations, the number of shares outstanding, or in case of non-stock corporations, the number of members. Third, as to each corporation, the number of shares or members voting for or against such plan respectively. Fifth, the carrying amounts and fair values of the assets and liabilities of the respective companies as of the agreed cutoff. Let me just make this little picture a little smaller than what it appears on the screen. Okay, thank you. Thank you for your patience. Following the contents of the articles of merger and consolidation, it says here, the method to be used in the merger or consolidation of accounts of the companies. Next, the provisional or pro forma values as merged or consolidated using the accounting method and such other information as may be prescribed by the Commission. We will now move to one of the more interesting topics, which is appraisal right. Take note, my dear friends, that appraisal right is a very significant corporate right of a stockholder. And this can even transcend financial and what we call this administrative matters. This can even touch on interpersonal relationship where a stockholder would like to leave the organization. So what is appraisal right? An appraisal right is a situation where any stockholder of a corporation shall have the right to dissent, disagree, and demand payment of the fair value of the shares in the following instances. So here is a situation where a stockholder disagrees and simply wants to leave by asking for the payment of the fair value of his shares of stocks. Now, what are the instances? Number one, in case an amendment to the Articles of Incorporation changing or restricting the rights of any stockholder or class of shares, or by authorizing preferences superior to outstanding shares of any class, or of extending or shortening the term of corporate existence. Remember, we touched about this earlier when we were talking about the term or life of the corporation. Second, in case of sale, lease, exchange, transfer, mortgage, pledge, or other disposition of all or substantially all of the corporate property and assets as provided in this code. Third, in case of merger and consolidation, in other words, what we have discussed a while ago, when there is a proposal to merge or consolidate your corporation with another corporation, that is an opportunity for you to say, I do not want to continue anymore, I disagree, and so you pay me now so I can leave this corporation. And the additional basis of appraisal in the Revised Corporation Code of 2090 is in case of investment of corporate funds for any purpose other than the primary purpose of the corporation. In other words, if you invested in a corporation, you gave in your capital contribution, it was because of a purpose that was told to you and stated in the Articles of Incorporation. However, when the corporation now is starting to decide to move its corporate funds to investments other than the primary purpose, then you may not want to risk your capital because such an investment may mean the bankruptcy of your corporation. So rather than follow them, you can now say, I exercise my appraisal right because I do not agree on the investment of corporate funds, for example, in retailing medicine for COVID-19. You're entitled to that and you can exercise your appraisal right. Just be careful in the exercise of appraisal right, which is the return of the investment of the shareholder, the so-called trust fund doctrine will operate. In that if there are any outstanding obligations, more reason if there is no retained earnings, then the appraisal right may not be exercised by reason of the trust fund doctrine, where the creditors are supposed to have reserve funds for them to be paid even before any shareholder can be paid. Now, moving now to another subject matter, and this is on the non-stock corporation and the trustee under Section 91. The number of trustees shall be fixed in the Articles of Incorporation or bylaw, which may or may not be more than 15%. So for non-stock corporation, it can be more than 15%, 15 trustees. They shall hold office for not more than 3 years until their successors are elected and qualified. Trustees elected to full vacancies occurring before the expiration of a particular term shall hold office for the unexpired term. Continuing with non-stock corporation trustee, except with respect to independent trustees of non-stock corporation, shall be elected as trustee. Unless otherwise provided in the Articles of Incorporation or the bylaws, the members may directly elect officers of a non-stock corporation. And so, ladies and gentlemen, I'd like to thank you very much for the coverage of the new provisions of the Revised Corporation Code approved in 2019. That is not yet the entire corporation code. There will be a series of YouTube uploads that will discuss the individual subject matters that will allow anybody to understand the details of the corporation code. The previous slide simply zeroed in on the changes that were initiated with the enactment of the revised corporation code of 2019. And so I would like to leave the subject matter and be sentimentally reminded of our dear Dr. Virgilio D. De Los Santos, for whom these fond memories are dedicated, particularly this discussion on the revised corporation code. Dr. Virgilio De Los Santos, for those of you who may not have known him, has a Doctor of Laws honoris causa from the University of Pangasinan. He holds a Master of Laws degree in International Law at Harvard University, USA in 1955, where former Senator Juan Ponce Enrile was his classmate at Harvard Law School. Before his Master of Laws degree, he finished his Bachelor of Laws magna cum laude from the University of Manila in 1953. And his pre-law is his Bachelor of Arts cum laude from the University of Manila in 1948. Dr. Virgilio De Los Santos is a very unique Filipino. He was a Japan Special Scholar at the Kokusai Gakuyu Kai in Tokyo and Fukuoka Kotogako in Fukuoka, Japan in 1943 to 1945. So when Japan was at the height of the Second World War, Dr. Virgilio De Los Santos was a student in Japan, and he almost got caught by the dropping of the atomic bomb at Nagasaki, where he was also a student. At the University of Manila, Dr. De Los Santos started his career as the Dean of the College of Law from 1962 to 1968. And he moved up to become Executive Vice President in 1959, became the President of the University of Manila and Chairman of the Board of Trustees and the controlling stockholder from 1981 to 2006, and he stepped down as President but kept his Chairman of the Board of Trustees from 1981 up to his sad death in 2009. Dr. Virgilio De Los Santos reminds me of some of my fondest moments at the University of Manila. My family is very close to the University of Manila. The father of my mother, my maternal grandfather, Attorney Sabiniano Hernandez Balagtas, is a 1950 graduate of the College of Law of the University of Manila. My own father, Captain Santos Vargas Bisquera, is a graduate of the University of Manila's Bachelor of Business Administration, major in management, and he managed to reach second year law in the same college where I am now the dean. And I happen to have cross-enrolled, and I have one subject from University of Manila, Roman Law, under then Attorney Michael Moralde, who became the dean ahead of me. When I passed the bar examination, I have not personally met Dr. Virgilio De Los Santos, but I had to struggle to be appointed as part of the UM College of Law. In 1994, President De Los Santos did not welcome me to be a UM bar reviewer, fresh from passing the bar, because he did not believe a new lawyer can become a good law professor, more so a bar reviewer. And so he asked the commitment of the then dean to tender his resignation if there is any student or any reviewee who will complain about my performance as a law professor and a bar reviewer at the University of Manila. It was a very tough screening that I had to go through even before I could personally meet Dr. Virgilio de los Santos, the then president and chairman of the board. However, having stayed with UM from 1994 to 2004, in those 10 years, I had the luck of meeting personally Dr. Virgilio de los Santos at the time that he had some legal statics with his favorite alumni association, PhilPedia, the Philippine Federation of Japanese Scholars. And I started working with him, and it was at that point that Dr. Virgilio de los Santos realized I was probably worth more than what he thought in 1994. And so, with frequent interaction with him, both on a professional and personal basis, in 2004, Dr. Virgilio de los Santos, with the recommendation also of now President Emily Dodson de Leon, insisted that I assume the deanship of the College of Law, and at the same time secretly help him prepare his holographic will. Dr. Virgilio and I had fun doing our legal battle together in corporation law concerning his alumni association, PhilPedia, but worse, facing some adventures, some statics in a couple of stockholders meeting where a member of his family would play some adventurous games on him. It is during those times that Dr. Virgilio de los Santos found in me not only a reliable professional, but a younger lawyer and probably a son he never had. About 11 years ago, I was told by my cardiologist in Makati Medical that I needed 5 heart bypass operation and had to go to it in 2009. And while I was in the hospital, I understand Dr. Virgilio de los Santos kept following up on my own medical status and whether I was doing all right. Until he finally heard I managed to go home and is recuperating in bed. Too bad. My beloved Dr. Virgilio was the one who picked up a very treacherous pneumonia and did not anymore leave Asian Hospital alive. And so in the last night of his wake at the University of Manila, I had to pick myself out of my bed to give my final respect to a gentleman, an intelligent person, the one who organized and continued to hold intact up to this point. Sir, I miss you a lot, and I wish you were still around to see that I'm back again as your Dean of the College of Law, struggling after 2 years that UM Law did not allow any one of its first takers to pass the bar. By luck again, just like in 2006, where we had 75% of our candidates passing, almost 100%, I am again tasked to bring back UM Law, your baby, your favorite, to where it belongs to. I almost gave you 100% passing mark for first takers in the bar in 2006. I have not given you a bar top notcher. Today, I struggle because of this COVID-19 pandemic. Our enrollment is way down, and yet we have to innovate in order to have your UM Law survive these online sessions. We are adopting these YouTube uploads as our lectures to our UM bar candidates and also our law students, aware that law students of other schools may in fact be also benefiting from these lectures. And we do not mind, because then they will see what UM Law is all about. On Saturdays, I meet online through Zoom Meet all our law students scheduled from 12 to 2 for the second year, from 2 o'clock to 4 o'clock for the fourth year and the bar reviewees, and 4 o'clock to 6 o'clock the third year law students. This kind of upload on corporation law is one of the components of mercantile law that we are uploading, so that it allows our students to study on their own these particular lectures. Sir, we miss you a lot. We know that you are always around. Your remains are in the chapel, and you will continue to be with us as we commit to you. The University of Manila will survive as an educational institution to continue to give glory to your ideals and to your dream of a school that will survive. So long for now, and I am so happy to have this opportunity to dedicate this corporation code lecture in your honor. Mahal ko po kayo, Dr. Virgilio de los Santos. Ladies and gentlemen, I'd like to thank you very much for this rare opportunity you have given me to lecture on the revised corporation law of 2019, and likewise dedicated to the fond memories of Dr. Virgilio de los Santos of the University of Manila. I hope you enjoy watching this particular lecture, as I am so proud and I enjoy bringing it to you a few hours before my birthday. Thank you very much. I'll see you soon.